Okay, let's unpack this. We are diving into a legal and cultural shockwave centered on a very familiar face from film and television, actor and director Timothy Busfield.
It's a huge story. And this is a case that involves, a high-profile celebrity, the really complex dynamics of a Hollywood production. And this is the key part. The extremely stringent, almost non-negotiable legal mandates of New Mexico state law.
Specifically, their laws concerning crimes against children.
Exactly. It is a perfect storm. We have sources that include the arrest warrant affidavit, we have the production company's internal investigation documents, medical records, and of course the specifics of the New Mexico statutes themselves.
So our mission here is to really cut through the noise and get to the legal core of this. What are the precise charges? What is the kind of conflicting evidence they use to even establish probable cause?
Right. And then what is the severe potential punishment under New Mexico law? That's what makes this case so critical. And maybe most immediately, why is the prosecutor fighting so aggressively to keep him locked up before a trial even begins?
That last point, the pretrial detention, that's the battle happening right now. And it tells you everything about the gravity of the state's case here.
It really does.
New Mexico law enforcement isn't just seeking justice in the abstract. They're responding with maximum legal force. They're declaring him a flight risk and a danger to the community.
Absolutely. The decision to file a motion for pretrial detention, which we're going to analyze in depth, it signifies that the prosecution is highly confident in their evidence, and they see the accused as someone who just cannot be trusted, even under the strictest bail conditions.
So let's talk about the timeline of the arrest itself, because it was just stunningly dramatic.
It was almost out of a movie.
Right. So Timothy Busfield, he's 68. He surrenders to Albuquerque authorities on January 13, 2026. This is 4 days after the warrant was even issued in Bernalillo County.
So he voluntarily traveled 2,000 miles to face the music. He knew it was coming.
Exactly.
Yeah.
But here's the part that just shocked everyone. Less than an hour after he turned himself in, while he's being processed at the detention center in New Mexico, heavily armed federal agents from the U.S. Marshals Service raid his home in upstate New York.
And not just any agents. This was the New York Regional Fugitive Task Force.
What does that mean? Who are these guys?
These are the people tasked with tracking down the most dangerous fugitives in the country. We're talking military precision, assault rifles, full riot gear, and they used a battering ram to get into his house in Highland Lake.
A battering ram?
Well,
he's already in custody.
The operational mismatch is just staggering. Busfield had already exchanged his suit for an orange jumpsuit, yet you have the marshals executing this high-stakes, violent search of his home in the Catskill Mountains.
So they're literally ramming down his door while he's posing for his mugshot in New Mexico.
Pretty much.
That's not just cross wires. That feels like a massive procedural fail.
It is an incredible display of, let's call it, bureaucratic timing failure. But the significance is exactly what you point out. It highlights the extreme urgency of the underlying felony warrant.
So once New Mexico police issued that warrant, the severity level just instantly triggered the involvement of the highest levels of law enforcement.
The DOJ, yeah. This initial drama just set the stage. It underscored that the state of New Mexico was pursuing this not as some minor celebrity matter, but as a grave threat that demanded immediate action.
So the show of force was very real.
Oh, yeah. Even if the timing was, let's say, tragically off for the marshals involved, the sources say they spent about 10 minutes searching the house, another 20 on the whole property, an RV, an outhouse, before they realized their target was already in a cell 2,000 miles away. Then they just left. Empty-handed.
Wow. Okay, so let's transition now to the core allegations. Where did this all start?
It all originated on the set of the Fox drama, The Cleaning Lady.
Right, which filmed in Albuquerque, and that's the key. That's what makes New Mexico the jurisdiction for these charges.
Exactly. And the charges involve twin boys, who are identified in the documents just by their initials, SL and VL. They were born in 2014.
So the alleged abuse began back in 2022, when the boys were just 7 years old.
Yes, and it allegedly continued up to the spring of 2024. So we're talking about a period spanning over 2 years across multiple seasons of the show.
And Busfield's role on the show was what, exactly?
He was a director and an executive producer. This placed him in a definitive position of authority over, well, over everyone, but specifically over the minors and their parents.
And that position of authority, that's going to be paramount to the prosecution's case, right?
Absolutely. Especially when we get to New Mexico's child abuse statute. Law enforcement doesn't view the set as just a neutral workplace. They see it as an environment that could be, ripe for exploitation.
Especially when the person allegedly committing the acts holds ultimate control over the children's employment, their whole career.
Precisely.
Now, the history of the investigation itself it's convoluted.
Yeah.
And I imagine that's a key factor the defense is going to try and exploit.
Oh, for sure. It's not a straight line.
We know the process started with a medical professional. An initial criminal investigation began way back in November 2024.
Right. A physician at the University of New Mexico Hospital notified police of suspected sexual abuse after examining one of the children, SL.
So that initial medical report, it's dated November 1st, 2024. You'd think that would be the starting gun for a full police probe.
You would think. But Officer Osborne initially contacted the Crimes Against Children unit, and for whatever reason, the case was determined not to meet acceptance criteria.
What does that mean, acceptance criteria?
It suggests that at that time, the medical observations alone, or maybe the child's initial disclosure, just wasn't specific or detailed enough for the department to dedicate full resources to a formal criminal investigation, so it just stalls. The state's case temporarily hits a wall.
And while that police probe was stalled, the whole matter kind of moves into the corporate and union sphere.
It does. Around February 17th, 2025, an anonymous complaint was filed through the SAG-AFTRA hotline.
And what was the substance of that complaint?
It was regarding tickling and caressing the head and body of minor boys by Busfield on the set.
That's interesting language.
It is, because while it's definitely inappropriate if true, it could also be interpreted ambiguously. Tickling and caressing isn't a legal term.
But it was enough to trigger the producer's internal response.
Yes. Warner Bros. TV, the show's production company, they hired an outside counsel, a Christina McGovern of Solomon Law, to conduct an independent investigation.
And that corporate probe concluded on March 31st, 2025. And the finding was, critically, no corroborating evidence.
No corroborating evidence. That's the key phrase the defense will hang their hat on.
So just to recap where we are, we have a police case that was deemed not worthy of acceptance and an internal studio investigation that found no corroborating evidence.
Right. If the timeline had stopped there, this case would have almost certainly faded away.
But it didn't. This is where it gets, as you said, really interesting. This is where a specific disclosure forced the police to reopen everything.
The sources pinpoint the exact date. September 2, 2025. This is the moment everything changes.
What happened on that day?
SL, the primary child victim, was speaking to his counselor, a woman named Yolanda Yeoman. And during this therapy session, SL makes a definitive and very specific disclosure. He says that Busfield touched his penis and bottom.
And that was it. That's the moment the ambiguity just dissolves.
Completely. The allegation shifted from this vague, inappropriate tickling to a specific act that meets the legal definition of criminal sexual contact.
And that level of detail, coming from a child in a therapeutic setting, that completely changed the dynamic for law enforcement.
It gave them what they needed to move forward.
Let's elaborate on those specific allegations, the ones detailed in the warrant affidavit. This is based on the safe house interview and the therapist records.
So SL stated Busfield touched his private area. He described it very clearly in, a child's terms as where he poops and pees.
Which translates medically to the gluteus maximus and the penis.
Correct. And what the warrant affidavit really emphasizes is the repetition and the setting of these alleged acts.
What do you mean?
SL specified that the touching occurred over the clothing. That's a critical detail we'll come back to. And he said it consistently happened in the short breaks between sets.
And it wasn't just once?
No. He estimated it happened 5 to 6 times for him and 3 to 4 times for his twin brother, VL. So this indicates a sustained pattern over time, not some single isolated incident.
And that specific, repeated, and consistent nature, that's highly powerful for the prosecution in establishing credibility, isn't it?
Hugely powerful.
The child's reported emotional reaction is also a big part of this. It feeds directly into the prosecution's argument about harm and coercion.
Yes. The affidavit notes that SL reported being very afraid of the director. He said he was scared after the sets were over that he would speed walk to his father and literally hide behind him.
And he articulated why he didn't tell anyone.
He did. He said he was afraid to tell anyone because Busfield was the director, and he feared Busfield would get mad. That speaks directly to the exploitation of that power dynamic we talked about.
And this isn't just, anecdotal fear. It's clinically documented harm.
That's the other crucial piece. The medical records noted that SL was diagnosed with post-traumatic stress disorder, PTSD, and anxiety.
And there were physical manifestations of this distress.
Yes, serious behavioral issues, specifically bedwetting, which is a classic physical symptom of severe trauma in young children. This clinical evidence moves the case beyond just he said, she said.
It provides objective proof of the damage that resulted from the alleged conduct.
Exactly.
So, to summarize the warrant, Busfield is facing 3 felony counts.
That's right. 2 counts of criminal sexual contact with a minor one for each twin, SL and VL, and 1 count of child abuse.
And we really have to stress the legal weight of a child's testimony in New Mexico. It's different than in some other places.
It is. The courts there recognize that crimes against children often happen without any adult witnesses. So state law allows the uncorroborated testimony of a minor child, if they're deemed competent to testify, to be sufficient substantial evidence to actually uphold a conviction.
So the child's word can be enough.
It can be, and when that testimony is specific, consistent, and then backed up by objective evidence of trauma like a PTSD diagnosis, the prosecution's case becomes exceptionally strong, regardless of what some prior corporate probe found.
Okay, so now we enter the legal battleground. This is the tension between the state's narrative, which obviously established probable cause for the warrant, and Busfield's very comprehensive defense narrative.
Right. To even get that arrest warrant, APD officer Marvin Brown had to present enough facts to convince a judge that a felony was likely committed.
And his affidavit is.
Yeah.
It's more than just a list of allegations.
It's highly analytical. He didn't just recite what he was told. He constructed a specific psychological and contextual argument.
How so?
He really emphasized Busfield's position of authority on this hectic film set. He explicitly wrote that pedophiles often infiltrate families under a trusted role, like Timothy, who, as a producer, exploited the hectic film sets.
So that framing is designed to preempt the defense's argument that any touching was just benign, playful contact on set.
It's designed to do exactly that.
The police probe also, crucially, interviewed multiple people from the set, and their testimony seems to support this idea that the environment was structurally enabling misconduct.
Yes, due to pervasive lax supervision. Let's look at the testimony from a production assistant, Taylor Trujillo.
Okay, what did she say?
She noted that Busfield was very touchy with certain people, and she described his conduct as very unprofessional. But that's not the most damaging part of her testimony.
What was?
It was about the supervision structure itself. That's the critical link to the child abuse charge.
Wow.
Taylor stated that set teachers are mandated by law and union rules to monitor the children at all times. But she said they frequently lost sight of them.
Creating opportunities for Busfield to be alone with the boys during filming.
Exactly. This isn't just about one director's alleged actions. It's about a structural failure in the safety protocols on that set.
And was her testimony corroborated? Does anyone else see this?
Yes. Another PA, Lauren Trujillo, confirmed this exact laxity. She specifically identified the set teacher, a man named Lee Lewin.
And what did she say about him?
She noted Lewin would often hang out with the first team, which is the main casting crew, where the monitor screens were unavailable. This could have allowed Busfield potential one-on-one time with the children in their room or holding area.
So the affidavit is painting a picture of, what? Criminal negligence.
Yeah.
A reckless disregard for the child's safety by the leadership on set.
That's the argument, and the emotional context is damning. A hair and makeup artist, Danielle Vigil, gave a statement that is just chilling.
What did she say?
She said that, and I'm quoting, "Everyone knew to avoid Timothy because he was creepy."
Wow. Everyone knew.
Everyone knew. And she also noted that the children were frequently left unsupervised by that designated set teacher.
That is a staggering detail. If multiple employees felt a director was creepy, and the mandatory child safety supervisor was repeatedly absent.
It directly supports the prosecution's argument that Busfield, as a figure of authority, was exploiting an environment of known and permitted endangerment.
There was another detail from Taylor Trujillo, wasn't there? About the parents.
Yes. She added that the boys' parents, who were not from the industry, didn't quite understand their rights on set. This suggests another layer of parental vulnerability that a perpetrator could potentially exploit.
So the state's case is built on 3 pillars, then?
I'd say so. 1, the specific, consistent testimony of the child. 2, the objective clinical evidence of trauma. And 3, the independent testimony from set staff confirming the opportunity for misconduct and a general atmosphere of unprofessional, lax supervision.
That sounds like robust probable cause.
It is. But the defense has a massive counter-narrative.
starting with Busfield's immediate, very public denial. He didn't just surrender quietly.
No, he released a video message. He said, "They are all lies, and I did not do anything to those little boys, and I'm going to fight it. I'm going to be exonerated." A very strong, very clear denial.
So the defense strategy seems to center on tearing down the motive and the credibility of the accusers.
That's a classic playbook. And their key claim is a revenge motive.
Explain that.
Busfield claimed in an interview with Officer Brown back in November 2025 that the show's lead actress, Elodie Young, told him the mother of SL and VL wanted revenge.
Revenge for what?
Because her sons were cut from the show's final season. The lawyer claims this entire case is a calculated effort to construct a case driven by animus, not fact.
So this is a powerful, a common defense strategy in these high-profile cases. They're suggesting that the specific disclosure in September 2025 was manufactured.
Or coerced by the mother after her professional relationship with the show soured.
But how do they counter the actual physical contact allegations? He was touchy, according to witnesses.
They try to distinguish between what they call acceptable workplace behavior and criminal contact. Busfield acknowledged that the set was a playful environment. He even admitted it was highly likely he had physical contact or tickled the kids.
He admitted that.
Yes, but he tried to frame it. He offered an anecdote about lifting a child who was following the twins and having him giggle to get ready to act, but he specifically denied remembering overtly tickling the boys ever in relation to this specific case.
So his argument is that the children were never alone with him.
He insists they were never alone on set without the teacher, a welfare worker, or a parent. The defense narrative is simple. Any contact was benign, public, and professional. That's it.
Which sets up a direct, unresolvable credibility clash for a jury. Was the contact benign and public, or was it targeted and specific, taking advantage of moments of lax supervision?
That's the whole ballgame, and this is compounded by the defense's reliance on that earlier Warner Bros. TV probe.
Right, the one that found no corroborating evidence.
Exactly. The independent investigation by Solomon Law, which concluded in March 2025, is being used by his legal team as powerful early evidence of his exoneration. The investigator from that probe even reiterated publicly that she found no corroborating evidence and that Busfield was never alone with the twins.
But this leads us to one of the most, fraught parts of the source material. The direct friction between the corporate investigation and the police investigation.
Yes. Officer Brown, the APD investigator, highlighted this in the warrant affidavit. He said the APD had significant difficulty even getting their hands on the WBTV report.
The friction here is huge.
It is. When Officer Brown sent a search warrant requesting production records, incident reports, and the WBTV investigation findings, Warner Bros. TV, through their attorney, immediately cited attorney-client privilege.
And they delayed compliance for nearly 3 months.
Almost 3 months. This delay is more than just procedural. It creates an implied narrative of corporate obstructionism.
And the investigator went further than that.
He did. He explicitly noted in his report that WBTV made it very difficult to obtain information for this case. And even more damning, that employees who spoke to the APD were very afraid of retaliation from Warner Bros. If they talked to the police.
And that completely changes how a jury might view the WBTV probe's no corroborating evidence finding.
It reframes it entirely. The defense presents it as proof of innocence, but the prosecution can now frame it as proof that the environment was so corrosive and corporate control was so strict that witnesses were too terrified to corroborate the claims.
Until the police and the specific disclosure from the child finally forced the issue.
Exactly. This isn't a procedural footnote. It's a central argument that the defendant was protected by a large corporation that actively delayed and, you could argue, obstructed an official police investigation.
The defense is clearly trying to overwhelm the state's case with counter-evidence. There's one final piece they proactively submitted, the polygraph.
The lie detector test. This is a highly specific tactical move, and it really capitalizes on New Mexico's unique legal landscape.
What do you mean? I thought polygraphs weren't admissible in court.
In most states and federal courts, they're not. They're viewed as junk science by many. But New Mexico is a notable outlier. A judge may permit polygraph results to be introduced, provided they meet certain foundational requirements.
So Busfield's team submitted results of a voluntary polygraph stating he passed regarding the allegations and denies the allegations.
Right. They're signaling that they intend to use this successful lie detector test as evidence of his character and his truthfulness.
Especially in this upcoming pre-trial detention hearing, where they're trying to demonstrate he is not a danger or a liar.
Precisely. They are using every available tool, exploiting New Mexico's legal idiosyncrasies, to argue against the prosecution's core claim that he is dishonest and dangerous. The fight over whether that polygraph ever makes it in front of a jury later on will be a trial within a trial.
Okay, let's transition now to the core reason why this case is drawing such national attention. And that's the sheer brutal severity of the potential punishment under New Mexico law.
This is the absolute center of this deep dive.
He faces charges under 2 key articles, right?
Yeah.
Crimes against children and sexual offenses.
Chapter 30, Articles 6 and 9. And you have to understand, New Mexico, often in response to high-profile tragedies involving children, has enacted some of the most punitive child protection statutes in the entire country.
What does that mean in practice?
It means the sentences for sex crimes against minors carry lengthy, mandatory prison terms. And they strip judges of the ability to grant probation or suspended sentences for that minimum term.
Let's start by breaking down the child abuse charge first. That falls under NM Statute Section 30-6-1. The definition seems incredibly broad.
It is. It focuses on the environment and the action of those in authority. It consists of a person knowingly, intentionally, or negligently causing or permitting a child to be placed in a situation that may endanger the child's life or health.
That word negligently seems critical.
It's everything. It means the state doesn't necessarily have to prove intent to harm. They just have to prove a profound failure to protect.
And who does this statute apply to? It's not just for parents, right?
No, crucially, it's not restricted to parents or guardians. It applies to any person who causes or permits the abuse. And the definition of criminal negligence here is key.
Which is what?
It means the person knew or should have known of the danger involved and acted with a reckless disregard for the safety or health of the child.
So in this case, the charge is for abuse that does not result in death or great bodily harm. What level of felony is that?
That constitutes a third-degree felony for a first offense.
And a third-degree felony is serious.
Very. It carries a basic sentence of 3 years imprisonment. But to understand the legislative intent, you have to compare it to the most severe version of that crime.
Okay.
If that same negligent abuse results in the death of a child under 12, it becomes a first-degree felony. And the sentence is at least 66% longer than the 18-year basic sentence for other first-degree felonies. It often results in life imprisonment.
So the fact that Busfield is being charged with a third-degree felony for merely permitting endangerment shows how aggressively the state uses this law to police the safety environment around children.
Absolutely.
Let's connect this back to the set environment testimony we discussed. The PAs said the set teacher was absent, the environment was unprofessional, Busfield was creepy. Could the prosecution argue that he, as a director, negligently permitted the boys to be in an endangering situation?
They absolutely can, and they will. His position of authority gave him a professional and legal obligation to ensure those safety protocols, which are mandated by state law and union rules, were followed.
So if he knew, or even should have known, that the set teacher was failing their duty,
and he took advantage of that failure to isolate the children, he has satisfied the element of reckless disregard. That meets the requirements for the child abuse third-degree felony charge.
it gives the prosecution a very strong secondary charge, even if the primary sex crimes are disputed.
It's a powerful backup. It ensures they have a path to a felony conviction, even if the details of the sexual contact get murky.
Okay, now let's move to the heart of the matter. The 2 counts of criminal sexual contact of a minor, or CSCM. What's the basic definition here?
CSCM, under NM Statute Section 3913A, is defined as the unlawful and intentional touching of the intimate parts of a minor.
And given the child's description of touching his pee and poop areas, that squarely meets the legal definition of intimate parts.
Yes, that includes the genital area, groin, buttocks, anus, or breast. The allegation fits the definition perfectly.
But the conviction, and more importantly the sentence, hinges on the distinction between 2 different degrees. This seems to be the legal knife edge on which his entire fate rests.
It is. Second degree versus third degree CSCM. And the distinction is crucial because of the sentencing mandates. The prosecution will, without a doubt, push for the most severe category possible.
Which is the CSCM second degree.
Under Section 3913B, yes.
And what elevates the charge to that second degree status in New Mexico?
It requires the contact to involve the unclothed, intimate parts of a minor who is under 13 years of age.
And if he's convicted of CSCM in the second degree?
He is guilty of second-degree felony for a sexual offense against a child. And here is the critical statutory language, which speaks to that legislative toughness we mentioned. The defendant, and I'm quoting, shall be sentenced to a minimum term of imprisonment of 3 years, which shall not be suspended or deferred.
Wow. That phrasing is absolute. A mandatory minimum of 3 years in state prison.
Which a judge cannot commute, cannot suspend, and cannot defer for probation. The moment a jury convicts him of that second-degree charge, he is locked in for a minimum of 3 years, period. Regardless of his age, his professional status, his lack of a prior record.
That is a massive legal threat. It removes all judicial discretion.
For a man of 68, 3 mandatory years is devastating. This is why the initial news reports were so quick to emphasize that 3 to many more years potential. They are directly referencing this non-suspendable mandatory minimum.
But here's the thing. The specific allegation from the child, SL, was that Busfield touched him over the clothing. Doesn't that specific detail immediately drop the charge down to the less severe category, the third degree?
That is the central fight the defense will wage. The CSCM third degree under Section C includes all criminal sexual contact of a minor under 13. That certainly covers touching over clothing.
And a conviction, there would still be a third-degree felony for a sexual offense, which is extremely serious.
But it lacks that mandatory, non-suspendable 3-year floor. The judge would have discretion.
So if the prosecution's main evidence only describes contact over clothing, why would they even charge the second degree initially? Is that just for leverage?
It's absolutely leverage, but it's also a strategic choice. They're leaving room for inference.
What do you mean?
The prosecution may argue that the nature of the contact, despite the child's memory of clothing, implies unclothed contact. Or they may hope the child's testimony evolves or clarifies during the trial. Or that the jury, swayed by the evidence of trauma and the creepy set environment, just infers that some contact must have been unclothed, even if the initial disclosure didn't explicitly state it.
But the defense will hammer that detail from the affidavit.
Vigorously. They will argue that the second-degree charge is legally unsound based on the evidence presented and should be dismissed or reduced.
So the distinction between clothed and unclothed is literally the difference between the defense fighting for probation versus a judge being compelled by law to send their 68-year-old client to prison for a minimum of 3 years.
It is the single most important evidentiary point in the entire case.
Which is why that child abuse charge is so important to the prosecution.
Exactly. It's their safety net. It's easier to prove, and it ensures they have a guaranteed path to a felony conviction, even if the degree of the sexual contact is successfully disputed by the defense.
Okay, so let's move to the immediate legal process. Busfield, after he voluntarily surrendered, is currently detained.
He's at the Bernalillo County Metropolitan Detention Center. He appeared remotely from there for his arraignment, wearing that ubiquitous orange jumpsuit.
And the arraignment itself was pretty standard.
Purely procedural. He did not enter a plea, which is expected for felonies this serious. His only statement to the judge was, "Thank you, Your Honor." The entire focus for the state right now isn't the trial date. It's the pretrial detention hearing.
And the DA's office, Sam Bergman's office, they immediately filed a motion to keep him incarcerated up to including the trial.
That's a declaration that they view him as a serious and ongoing danger. The prosecution's argument is explicitly stated in the motion. No conditions of release will reasonably protect the safety of any other person or the community.
And New Mexico has some unique rules about this, doesn't it?
It does. It has strong constitutional protections against prevented detention, but it allows for it if the state can meet an extremely high legal bar.
What is that legal bar?
The prosecutors have to prove by clear and convincing evidence that pretrial detention is necessary for public safety.
And that's a much higher standard than probable cause.
Significantly higher. It means the DA can't just rest on the arrest affidavit. They have to present compelling, robust evidence. Often that means live testimony from the investigator or the child's counselor, or maybe even those set PAs, to convince the judge that releasing Busfield presents an unacceptable risk.
So the DA will focus on the severity of the crimes, the exploitation of his authority over children, the PTSD diagnosis, all to argue he is a danger.
Right. But the defense has strong arguments against detention.
Like the fact that he voluntarily surrendered. That doesn't exactly scream flight risk.
That will be their main point. A 68-year-old celebrity with resources, strong family ties, and no criminal history who voluntarily flew 2,000 miles to face the warrant is the literal antithesis of a flight risk.
So they'll argue for house arrest or electronic monitoring.
Yes, but New Mexico judges often define danger to the community very broadly in child sexual assault cases. They focus less on the risk of flight and more on the potential for reoffense or any contact with witnesses.
And this is exactly where the defense's strategic use of the polygraph results comes back into play.
Absolutely. They are trying to chip away at the prosecution's claim that he is a serious and ongoing danger. By proactively releasing information about his successful lie detector test, they hope the New Mexico judge will consider this non-traditional evidence as proof of his truthfulness.
And by extension, that the allegations are false and he poses no risk.
It's a calculated attempt to use New Mexico's specific rules to overcome the very high bar set by the DA.
And beyond the courtroom, we're seeing the immediate, devastating collateral damage.
Oh yeah, NBC pulled a guest star episode of Law & Order, SVU, that was scheduled to air just 2 days after his surrender.
In which he was, ironically, playing a judge.
The irony is thick, but it reflects the entertainment industry's instant, absolute, zero-tolerance policy in these situations. For Busfield, the legal fight for his liberty is happening at the same time as the complete destruction of his professional reputation.
It's a testament to the speed and finality with which allegations like this destroy a public career, regardless of what eventually happens in court.
The court of public opinion moves much faster than the court of law.
So this entire incredibly complex case hinges on the credibility of a single child's specific detailed disclosure.
Which came months after an initial investigation yielded nothing corroborated.
Against the backdrop of a plausible motive for revenge put forth by the defense.
And the highly specific, non-negotiable, mandatory sentencing laws of New Mexico.
It's set to be a tremendously difficult trial for both sides, and the immediate battle is just about whether the state can prove he is too dangerous to walk free while he awaits that trial.
A truly high-stakes legal drama.
So let's wrap up this deep dive into the legal crisis surrounding Timothy Busfield. We've really established this central polarized conflict here.
You have the detailed, specific claims from the child victim SL's disclosure to his counselor about touching his penis and bottom, and that's supported by clinical diagnoses of PTSD and anxiety.
And on the other side, you have the defense's powerful narrative of a revenge motive, bolstered by that prior Warner Bros. TV probe that found no corroborating evidence.
And most critically, we've decoded the severity of the legal stakes under New Mexico law. Busfield is facing charges that, if convicted of that criminal sexual contact of a minor in the second degree,
The one requiring unclothed contact.
he faces a mandatory minimum 3-year prison sentence. It cannot be suspended or deferred. And the immediate, intense legal struggle is over that pretrial detention, where prosecutors must prove by clear and convincing evidence that he is a serious and ongoing danger.
And the defense's use of the polygraph results is that highly specific tactical countermove designed specifically for the New Mexico court system to argue against that.
Yes, and the complexity of the trial will really revolve around the legal interpretation of that child abuse statute. The New Mexico legal system applies criminal liability not just to parents or guardians,
But to any person who causes or permits a child to be placed in a situation that endangers the child's life.
right. And given the testimony from the set crew, the production assistants, the hair and makeup artist who noted the director's position of authority, the set teacher frequently losing sight of the children, and the environment being generally unprofessional and lax.
That raises the final provocative thought we want to leave you with.
How might a New Mexico jury ultimately weigh that broad legal definition of permitting endangerment, particularly in a high-pressure commercial setting like a film set?
Yeah.
Could the prosecution secure a conviction solely based on the structural failure of Busfield as a figure of authority to maintain a safe, supervised environment for children, which his own crew testified was precarious?
So if the standard for that particular felony is just reckless disregard for the child's safety,
The testimony about the set environment alone may provide the state with a robust alternative pathway to liability, completely separate from the outcome of the sexual contact charges. It could transform the definition of the crime from a specific act to a fundamental failure of duty.
a truly complex legal fight played out under some of the toughest child protection laws in the country. Thank you for walking us through the sources on this dramatic case.